week, Thursday, July 20th, and Ebeka say court sitting a course. Na Richie Jakpa after the court case, Eba Beka Simbi, and headline Annie Free Mobile say, I told the Attorney General to end my trial because I cannot trust the judge. We are Richie Jakpa and somebody be to you. The tough and boy now and say, oh no, or see on J. Yama make Justice Efia Serwaa Botwe. I no a court of appeal judge. In this case, or a certain trial judge, Japasi on Jinindi. The antina one Jinindi, you know, we will answer, but in the communication a free Yama made Justice Efia Serwaa Botwe to Richie Jakpa and say, Jakpa, Thursday, I am meeting you in court. Tuning class, Thursday, all parties are served in this ongoing ambulance trial. No? Thursday, area 12, everybody should be seated in court. And him say, Mami Justice Efia Serwaa Botwe so. But Tenasi will court on permit, TMOBM will continue. If you want to be part of the proceedings, you should be seated before the Court of Appeal Judge, Justice Efia Serwaa Botwe, Ebe Tenasi. Na DNT and our this anchor to aba. Japan sema na opese oka said the Chief Justice should intervene and change the judge in the ongoing process. Isan say he feels say you can't semno ekoku all parties file on disclosures we on final written submissions ekoku piemu e judge na so ye na say judge na e mandate say we ti obi asem okwa tena dem akin kan in some evidence I wo hono no nyina akwa bibim no the judgment abetuja. Richie Jakpa stated emphatically clear last week in court, June 20th, said, on no dear, OGD said, a fiancé and Obanko P. Now, said, it will be difficult for him to reach out to the learned Attorney General to facilitate bail conditions for him. I think so, it will be difficult for him to get in touch with Onwankasani Bushoni, JNC Emmanuel Johnny Kulengi. Into no dear on person justice if you are Serwaa Botwe ebe kansem no amana kwa kusipi amana kwa kusinyemi and ninti on any lawyers file submission of no case Attorney General a contend ye ni bu fu is on there we declare war na kwan bia so obefa obe deal with the Attorney General no obe deal with him including using underworld tactics. Now, she say a response here, but say, the Court of Appeal Judge, I says Thursday or tonight case, the emphasis and on the grounds based on three things is and say based on common law, a judge can only be asked to recuse or be recused from a case when one, the judge has self-interest in the ongoing matter. Yes, I some idea to court judge now tiasem as some the fan of one. In this ongoing ambulance trial, so Richie Jakpa, EPCS Sana, Judge na Justice Efia Serwaa Botwe. The first question about Judicial Council in this matter, the Chief Justice of Ghana, Emame, a leadership Justice Gertrude is about to kono enemy say Justice Serwaa Efia Serwaa Botwe on your trial judge no. Ambulance in sense ni hu bom na number 1. Onim case out of force yana, onim Richie Jakpa na. Is she in any way contacted with Big C's Company Limited almost supply ambulances here now? And you be a near mommy or your Ministry of Health during the time of the procurement of the ambulance process and was she in any way working at the Ministry of Finance and the same way you said no. Justice Efia Serwaa Botwe has no self-interest in the case. On to me and share the Chief Justice Chinchina on Sasano. And in this case, the learned Court of Appeal Judge Efia Serwaa Botwe does not fall in the category of self-interest. Number 2, the issue of bias can also be raised. A judge now in the ongoing hearing process, has she been biased towards one party? Otie Attorney General no say more than say Otie the accused persons now. In this case, the trial judge has made it so clear. So be how the assembly be it said the matter is of interest to the whole state, is of interest to the whole public, including even admitting into evidence a 14-minute tape beer NDC case at the force Richie Jakpa and the court name as supplementary affidavit. even at the time nobody kind of witness statement on wabekasa tape you won't send by and relevant even to the ongoing matter as said by most lawyers. The trial judge, Court of Appeal judge, Justice Efia Serwaa Botwe, edgy to admitted to evidence. To the extent to say during her delivery of the ruling on the Bible Tujan, or can say, well, tape no mark 10 times, 10 solid times. I want to be Bia say Attorney General, catcher Jakpa, say Jakpa, and can be amani implicated at force. So they cannot raise the issue of bias. Last week, Attorney General submitted 68 WhatsApp messages. Lawyers for the accused, Dr. Abdul Basit Bamba, Thadio Sorry, Eduji Tamaku, raise objection. Say, Omunyan text message in Tiabeya, Congo, the trial judge heard their plea. And more time say, Omun Colum Coifim, Omun resume sitting. She's going to give them time for them to argue. And Pampa or Moma Bremubian and listen to the Onoe no say, more the evidence about a tip on my Giatumo. More had the 14 WhatsApp messages about Amamanjia Tommy Yusu in the ongoing trial as evidence. DNT and prosecution, and so the more evidence about with regards to further text messages and custom and unique and no kind Emma court one man in Tiasia Juma. Advisor or the man, the learned Attorney General, Godfrey the about them sent Kebeya. On na kwakudin komo tinka ontwe ho kakra na nka case na ento aso even though say on share no peme Attorney General tie Emma yemu say ampa amena ruling no the by judgment no by ne kwan so ano no Emma Director of Public Prosecutions Yvonne Atakrobo Bisa and to aso with cross examination Deputy Attorney General afetwa ye bo amonso e kan ho bi ana Attorney General te hono mo a yenhunu say okasa ni nyina to foster fairness in the ongoing trial. So Richie Jakpa and case out of force in they cannot submit any appeal, said the trial judge, intimate case so on the basis of bias. The last thing I'm come back to me, so they are preventing them from continuing the ongoing trial, and they say, I'm to me a pinpoint by beer. Yeah, my Justice Efia Serwaa Botwe, Ejina, I hear any prejudicial comment regarding the case. Say, I see me young can be maybe a hawker, any of the parties, say, ukwe fiasia udibisho nyansa and how many we are couldn't come out no catch media na waka found there has not been the mention of anything like that in the ongoing trial, and you know they cannot pinpoint to the fact that Justice Efia Serwaa Botwe has been prejudicial. And the way you know all these evidence and facts and I'm in the community no akọ e dia mo say e court and tenacia na say there is anything like recuse and command ekoso Thursday court tenacia ye ba bia na say asesa judge na betina case so in transfer no free Accra emfa nkowa for a new judge to be appointed bibia sense here the time so for retirement they say Justice Onyenuga in the ongoing open trial army asesa na new trial judge betina so bibia sense here, so she's going to continue with the court sitting and they appeals court one na application on file or I am almost say within 7 days you should file the written submissions and no any more time so on finding na Yankopon yadoma Thursday and then 25th June Thursday 27th June 12 p.m. 12 noon yes and the Economic and Financial Division of the Accra High Court the ambulance trial is going to continue. Justice Efia Serwaa Botwe, the trial judge on Noah and a better case. So it's a Richie Jakpa, see on trust now on Uninia, on my court ho, now make sure the on Unindi, na Ghana Funina.
Then they came to court having studied it and they raised objection. And they will not allow the Attorney General to tender the rest of the text messages. I've never seen something like that before. A set of text messages exchanged between two people. 68 text messages exchanged. Jakpa tenders 14, representing 25%. And the Attorney General says, okay, no problem. I'm happy to tender the rest of the 75%, including what you have already tendered. It will still be in my own. So I'm tendering to the court 100%, which includes the 25% that you already have. And Jakpa admits that, yes, there were several text messages between me and Attorney General, but most of it was motivational message. Every morning I sent to him, God bless you, and don't worry about your enemies. You go forward and soar like an eagle, and those things, Psalm 91 and Psalm 134 and something like that. That's what he said. That he's been sending the text message to the Attorney General. He's been sending motivational messages to the Attorney General. As we go on in this narration, you will see him describe himself with having some spiritual power. So I'm not so sure what kind of motivational messages he was sending, but you'll see that. And then the court said, okay, no problem. Whether it's motivational messages or not, we understand. But you accept that the text message that you sent was short of the whole? He said, yes, it was. Okay. Attorney General says, here is the lawyers for Jakpa says, we don't like it. You cannot tender the whole. I don't understand it. The lawyers for Jakpa says they will not allow the Attorney General to tender the rest of the text messages. That is what Adiosori told the court today. He will not allow it. He's objecting to it. Text message that you have tendered some. I am bringing the rest. They said, no, they won't allow it. Viewers. Well, the judge is here to determine. But in any case, thank God, the judge overruled them. And so the text messages were admitted. That's the first thing that surprised people today. So the text messages were admitted. It says the court admitted the tapes into evidence, the text into evidence because they were relevant and had no issue of authenticity. That is to say, there was no authenticity problem. On the backdrop of the fact that Jakpa admitted that he did not tender all the evidence. This is the basis on which the court overruled the objection that was raised by lawyers for Adiosori. We don't lawyers for Francis Jakpa Adiosori. We don't know whether they intend to repeat this application in the Court of Appeal, where they could go and say that the trial judge erred in admitting the rest of the text messages and therefore the appeal against. Let's wait and see what happens. But they were overruled on this one. So the messages have been admitted into evidence on the basis that they were relevant and that they have no problem with authenticity because the court has looked at it and it seems authentic. And it is on the backdrop that Jakpa himself has tendered part of what you are saying you will not allow. And the part that you say you will not allow, Jakpa also has evidence of it. So why won't you allow it? Viewers, are we understanding, are we getting to the meat of the matter? The people don't want the text. They have tendered some. This is the rest of it. The rest of it is on their phone as well. They can easily say, no, this one was not part of it. That is why they were given 48 hours to study it. It was given to them on Tuesday. Study it because your client Jakpa has it on his phone. So take the printout and check with Jakpa's phone. Did he say, hey, how are you? I like your red tie. I like your red tie. How are you? How are you? Is the traffic bad? Is the traffic bad? You can just compare and look at it and see that this is authentic one. They were given 48 hours to do that. They were not able to come to court to say that, hey, this word has been omitted from this one. They were not able to say that. Just that they will not allow the document to be tendered. They were overruled. So that has gone into the evidence. We'll see what weight will be put on it and then we can move on. All right. Then the next one. Whether the AG forced Jakpa to testify, etc., etc. Okay. So Francis Richard Jakpa told the court that he sent documents to the Attorney General by phone when they met in Justice Kulendi's house, and that it is these documents that Attorney General was using to prosecute him. So today he came into the witness box, and then the Director for Public Prosecutions was with him. And Director of Public Prosecutions said that, Mr. Jakpa, you have told this court that you sent documents to the Attorney General, and it is these documents that are being used to prosecute you. He said, yes, I said that. It's true. He said, okay, take a look at these documents. So he looked at them. Are these the documents? He said, yes. Then the DPP told him that, I'm suggesting to you that these documents were filed on the 29th of March. Were filed on the 16th of March. And then your conversation, your sending to the Attorney General was on the 29th of March. So by the time that you were sending it to the Attorney General, it had already been filed in court. Then he was there. He was in the witness box. You said you sent these documents, and it's these documents that have been used. Okay, the dates show that whilst your allegation claimed on 29th of March, the Attorney General filed these same documents on the 16th of March. So you see, when you are dealing with lawyers and Attorney Generals, you send a document to them, they will not say anything. They will, okay, thank you. They won't tell you that, oh, this document, I already have it, I filed it. Lawyers don't do that. Serious lawyers don't do that. So I think that's what confused him. When he sent the document, I tell you, I didn't say that, oh, I already have it. So he thought, he's boldly he has seen the kind of person they may have been dealing with. I think by now they are getting it. I think they are getting it. But anyway, let's read it. Jakpa earlier claimed that on 29th of March, the Attorney General assured him that he will let him go scot-free. Oh, sorry, this is about the submission of no case. I'll come to the text message in a minute. This is about the submission of no case. The date I used is submission of no case. Jakpa earlier claimed that on the 29th of March, the Attorney General assured him that him go scot-free at the submission of no case if he testifies against her to force him. However, the Attorney General had already, on the 16th of March, filed a document saying that Jakpa indeed had a case to answer. So it's very similar, but this is about submission of no case. So on submission of no case, Jakpa told the court that Attorney General assured me on 29th of March that my submission of no case will be upheld by the court, or that he will not open the court will sustain his submission of no case. The Attorney General can assure him that he will not oppose it, because opposing the submission of no case or not is within the Attorney General's power. What the verdict the court will give is not within the Attorney General's power. So Jakpa was suggesting that the Attorney General promised him that he will not oppose the submission of no case. He filed his documents in 16th of March opposing the submission of no case. He had already opposed the submission of no case on 16th of March. Jakpa says on 29th of March, he told him that he will not oppose it, but the thing had already been filed. So they are trying to suggest maybe you're not being truthful. But the judge will look at all of those things in some detail. This was one of the shocking ones. This one and the spiritual one, they were the shocking. That former finance...
In some PTV near